Mr. Hensarling from Texas.
Thank you, Madam Chair. Governor Raskin, I want to follow up on a question that my colleague, Mr. Royce from California, was asking you. I want to make sure I understand this well. I believe that essentially your testimony is it is the interpretation of the Fed under the statute that you cannot recoup fraud prevention because that is a fixed cost, correct? Is that a fair assessment of the Fed's interpretation? So apparently it is not.
Not exactly, no.
Okay. What is it exactly?
Okay, let me...
I still don't understand this,
okay.
and I've been listening carefully.
So in terms of what can and can't be done, the statute sets out allowable costs, it sets out disallowable costs. But then there are costs, like you mentioned, which were not explicitly put into either allowable or not allowable.
Well, I thought I heard you say that actual fraud losses may be a permissible cost to be recouped in response to his question. Did I hear you correctly?
You did.
Okay. And you also allow for the possibility that fraud prevention costs may not be recouped. Is that correct?
That is also correct.
Okay. So does that mean that we could end up with the rather perverse conclusion that if a credit card company prevents fraud, they don't recoup their cost, but if they allow the fraud to take place in the system, you will allow them to recoup their cost?
Well, obviously this is why we want to collect comments. So we want to make sure that when we hear of different combinations of things that we don't allow what is a very difficult statute to...
Well, the world works off of incentives. If I was a credit card company and you wouldn't allow me to recoup my fraud prevention cost and you would allow me to recoup my fraud cost, I guess I would allow fraud in the system. My guess is that would not be good for our economy. Looking at the Federal Register of December 28th, when you asked for open up the comment period, you said there's no single generally accepted definition of the term incremental cost. Yet again, you seem to interpret it in such a way that fixed cost would not be allowable. But on page 81736, I read the board requests comment on whether it should include fixed cost in the cost measurement. So it seemed, and maybe I'm misinterpreting something, it seemed like on December 28th, you interpreted the statute to permit fixed cost to be recouped, but I think you're saying in your testimony today your interpretation is different. Is this correct?
Let me try to clarify what our understanding is of the statute. And it is a difficult statute to interpret.
Well, could you help me here? Is your interpretation different today than it was on December 28th when you put out the, it is not?
No.
Okay, so on December 28th, I don't know, I don't believe I'm taking this out of context. The board requests comment on whether it should include fixed cost in the cost measurement, which it seems like if you haven't changed your legal interpretation on December 28th, you agreed that you had the flexibility to put fixed cost into the incremental cost measurement.
And we requested comment to hear what those costs might look like, to see essentially whether we could move them through another part of the statute regarding functional similarity with checks, which is also required by law. So we needed to understand what the dimensions were of the different...
So you think your hands are tied, but they're not tied by that particular language. Is that what you're telling me?
Well, they're tied in various ways, but in terms of that particular language, you're describing a part of a category of costs that the statute is silent on. And I think what we need to do is understand what that category of costs could include.
Well, I'm trying to understand your legal interpretation, where Congress may need to act, where Congress may need not to act, and it still appears to me you're saying that fixed cost could be part of the transaction fee that you set. I see my time is running out. I know that under the statute you were to consult with other federal agencies. I got to tell you, my mailbox is full from community banks telling me that this is going to harm their bottom line. Let's put the consumers aside for a second. We've discussed that. But a number of small community banks said, we're going to get left out of this system. It's going to hurt our net revenue. I'm concerned also, what is the impact on their bottom line? And did you consult with the FDIC? I know you're a bank regulator, the other bank regulators. Ultimately, what will be the impact when fees, by some estimates, are going to be reduced 73%?
Yes, and the law requires us to consult, and we would consult anyway with our colleagues in the other banking regulating agencies. And yes, so we have spoken to FDIC, NCUA, OCC, Small Business Administration, and others. We continue to have discussions with them. As recently as yesterday, the NCUA has essentially looked at the issue of exempting small banks from not just the portion of the law regarding interchange, but the other portions as well.
Thank you. Mr. Scott.